Good afternoon, everybody. My name is Kathy Purdy. I'm the marketing manager here at Schoeneck King. I'd like to welcome you to this week's Coronavirus Weekly webinar. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will get to those as time allows throughout the presentation. And if you would take a moment to complete the brief survey once the webinar has completed, we would truly appreciate that. Our attorneys value your comments and suggestions, and they do look at those. So now to get things started, I'm going to hand it over to Pete Jones.
Kathy, thank you. Good afternoon, everyone. We've got a very full program for you this afternoon. Everybody is committed to me to keeping on time, so I'm just going to make that little announcement to ensure it. We're going to start off today with Chris Kurtz. Chris is in our Garden City office, and he's got some thoughts on pandemic planning for public employers. Chris, take it away.
Sure. Thanks, Pete. It's good to be back. Look, in true 2020 fashion, I'd say I have some bad news, and I also have some more bad news. The bad news is it looks like we're not out of the first pandemic here. We're still in COVID-19, and we'll be seeing how that plays out through the fall. But the additional bad news is that we also have to plan for the next pandemic. That's where we're at. On Labor Day, actually, on September 7th, the governor signed legislation. And that legislation was an amendment to the New York labor law, and it added a section 27-C. And what that does is that requires public employers to create a pandemic operations plan. Now, the question that arose, and there was some issues at first, were when is this effective? The legislation itself said that it goes into effect 30 days after it's signed by the governor. And like I said, it was signed on in sort of a ceremony, a political ceremony on Labor Day. So that would make it on or about October 7th. And I think there was a lot of confusion, and that seemed a little bit rushed considering what was required to be included in that plan. But if you look at the governor's approval memo for the legislation, and then also a little bit more informally, the press release that followed, he made it clear that due to sort of a deal with the legislature, the effective date has been pushed back until April 1st, 2021. And so for public employers, that date has a lot of meaning because that's also the date that you're required to have your police reform plans in place. So, that's going to be an important date as we move forward into 2021. For public employers, the definition of public employers is sort of the traditional, right? You would expect cities, counties, towns, villages, political subdivisions. The law, at least as respect to 27C, specifically says that it does not include school districts or BOCES. But what the legislation also does is say, well, it's not included in the definition of a public employer for 27C purposes. The legislation does amend education law, and it amends 2801-A to require that the school safety plans that school districts currently prepare in about October of each year, and that deal with sort of the violence issues and the safety issues that take place in schools. Well, the state wants you to include now protocols for public health emergencies and things that grow out of the next sort of communicable diseases emergency. And those plans, and what you're supposed to do is take the protocols for these pandemics and add it to your safety plan. And they should be the things that are, quote, substantially consistent with the types of things that other public employers are required to include in 27-C. And just sort of as a brief, recap, we laid out a lot of these in our blog. We have a labor blog that most of you are probably on already. We have a September 22nd post that lays these details out. But what you're required to include are the list of all your essential titles and the justification for those titles. There's really kind of about 7 categories, I think. Many of those will be what you already did in April and May and June when the first sort of decisions on essential titles came out and you were trying to deal with COVID-19 and figure out, who was essential, who was non-essential. Well, now we're supposed to create a list. Many of it will be the same, and a justification for why, you've deemed them essential. Secondly, with respect to the non-essential employees, you're supposed to come up with a plan and protocols for them to work remotely or to telecommute. Those plans will include, getting laptops, getting cell phones. How are you going to let those additional employees work from home during the course of the next pandemic? The third point, how, to the extent possible, are you going to stagger your work shifts? A lot of that, and it seems like the rationale for the staggering seems to deal with public transportation and the ability to get to work. You would think it deals with, what goes on locally at the workplace. But I think it'll have more impact on larger sort of metropolitan areas, bigger cities and counties where public transportation may be more of an issue. But they don't want everybody, commuting to work at the same time on public transportation at 7 o'clock in the morning, 8 o'clock in the morning, and then commuting home. So, are you staggering shifts? Are you working into the evenings? Are you doing 1 day on, 1 day off? Are you doing, 1 week on, 1 week off? Obviously, there'll be collective bargaining implications that you may need to sort of address. These will be fact specific as we move forward, right? So all pandemics are not created equal. We'll have to see what pops up and what that requires, and how we work that into the collective bargaining agreements. But we've done it once before, and look, the state wants us to plan ahead. The next requirement is that you have protocols in place for obtaining all your PPE. A lot of municipalities work through their county Office of Emergency Management. Some went to private entities to obtain that. How are you going to get all those face shields, face masks, gowns to the extent they're required, gloves? You start to have those suppliers in place so that they can be easily called upon when you need to. You also have to have protocols in place for if employees are symptomatic. What are the leave options? Again, a lot of those may be dealt with by executive order. You have to be able to keep track of where your essentials are working and what locations they're working in. Why? Because you need to be able to contact trace should they come down with COVID-20 or COVID-21 or whatever that next pandemic is going to be. And finally, and I think this is something that's a little bit more, again, geared towards a metropolitan area, they want you to identify emergency housing sites for your essentials, ostensibly to keep them local and not commuting should that be required. That's not something I don't think that really came into play too much in this current pandemic, but that is at least one of the requirements. So, those are the types of things that should go into your safety plan. For your public employers, you are required to get that draft plan to the unions within 150 days of the legislation. That date on or about February 4th, 2021. Get them a draft. They are allowed to make recommendations. They will review it and provide those recommendations to you as the employer. It's a whole separate webinar or separate call as to whether those issues are going to be negotiable or not. But that's something to stay tuned for. Certainly, if you get requests from unions to negotiate those, I don't believe the legislation requires that. Once the unions make their recommendations, you must, as the employer, respond in writing within a reasonable time frame as to whether or not you've accepted those recommendations. So there may be some collaboration that needs to get done to sort of, short circuit and to speed up that time frame. And ultimately, look, we have to get this done by April 1st, 2021 for the public employers. When you're done with it, you have to post it, right? You got to get in your handbook. You got to put it on your intranet. You got to put it up on the bulletin boards where you have your FMLA provisions. And it's sort of like a typical policy. So, stay tuned and sort of get planning on those. And finally, the DOL is setting up an online portal for employees to complain, essentially, and to reach out and say, look, in the next pandemic, that your employer is not following the things that are in their plan. So there'll be an avenue there, as that will probably be the first thing that gets done. But, we'll go from there and keep on top of those plans.
Chris, reminds me a little bit of the workplace violence prevention legislation insofar as it only applies to the public employers.
Yeah, it does. I mean, that was in 2006, right? It required us to do an assessment first and then kind of keep on top of it on an annual basis with training or updating the policy. It is unique to public employers. And, by and large, I think public employers handled this, really well, COVID-19. We were dealing with that 202.4 for a long time, and I didn't see a lot of lawsuits. I didn't see a lot of challenges. You didn't hear a lot of public complaints about how it was being done. So, it's a credit to the public employers out there that handled it the right way. But I agree with it in terms of that foresight and planning.
Thanks, Chris. Okay, let's turn to Bethany Centrone. Bethany's in our Syracuse office, and there's a lot going on with schools, so we thought it would be a good time to do another update on where we are. Bethany, take it away.
Thanks, Pete. Good afternoon, everyone. I'm just going to touch on a couple of things that happened last week in relationship to schools. The first, a quick note that the Department of Education, I think these things that would be interesting to everyone, not just those who are from schools. The Department of Education issued a letter last week indicating that state assessments and whether state assessments will be administered next year is actually is up in the air. I think most of us have gone into this school year assuming that they would be administered with these robust reopening plans and distance learning that school districts are doing. But the state has determined that testing is going to have to be in person to be implemented faithfully, and that if safety precautions are not able to be administered or it's not safe at the time, they could be canceled again. I mean, that's not that we should anticipate that happening, and our children and our students shouldn't be working to become competent in the areas that will be tested. But it is interesting to know that the state has already come out to say that it is a possibility that there won't be state assessments next year, and are looking to the federal government, which at this point in time has indicated that there won't be waivers of the federal requirements for states to have assessments at the end of the year. So obviously a lot could change between now and the end of the school year that would change people's thoughts about assessments at the federal level. More interesting and to all of us as employers and as school districts and as parents, the New York State Department of Health issued a new toolkit, they call it, in relationship to students and employees when they can go into a school and when they can return to school after any kind of COVID-related incident. You know, and unlike most stuff that the state has been issuing these days, it's actually quite clear. It's a series of about 9 slides, which are all flowchart related, and just goes through each type of instance as far as exclusion from school or return to school. The first, when can my child go to school today? Takes you through the list of things that would prevent a student from being in school. Have they been tested for COVID? No. If it's yes, then they have to, they either have to have a negative result or they have to wait until the result comes in. Obviously, if they're positive, they can't come to school. If they've been within a restricted area for the last 14 days, either a state or a country, or been in contact with someone that has tested positive, they cannot come to school until they're released from quarantine. The more salient change actually that came up in relationship to students returning to school is that previously the Department of Health guidelines stated, some of us had suggested to try to get around it a little bit, that students could not and staff could not return to school if they had a COVID symptom until they had a negative COVID test. And that really, really upset many people, because COVID symptoms are pretty ubiquitous as far as any kind of type of, and Pete just posted the link to the toolkit, short, a runny nose, a cough, headaches, sore throats, things that would be common to many other types of other conditions. Every day you had a headache, you'd have to come in and get a COVID test. And the Department of Health has sort of relaxed those requirements to say that if you have a COVID-related symptom, it's still recommended that you be tested, but you either have to be tested and get a negative test, or you can go to your healthcare provider and be evaluated, and have a note from your healthcare provider that says that it's not COVID, and you can return to school or to work with that. Another significant change that is in this guidance that's directly opposite of what had been in the prior guidance is that if school staff travel to a restricted state or a restricted country, previously there was available to school employees just like every other K-12 school employees, just like every other employer in the state for essential workers, so that you could, if you got a negative test, you could return to work. And the guidance currently, as of last week, apparently wasn't discussed with anybody, and related to schools, says that the essential worker exception, that no school staff are considered essential workers for the purposes of travel to restricted areas. We can only assume that that's because, the likelihood that children are going to be, or people will be contaminated or catch COVID. If you come back, even if you've been tested negative, you could still have it. It could be dormant still. And so that's no longer available for employees who travel, no matter what the reason for the travel. The other thing I would like to point out in relationship to the guidance is that when we're looking at symptoms, it's whether you have new or worsening symptoms. And so, for example, if your child has asthma or your child has allergies, if you have allergies on the first day and you go and you get a doctor's note, and then you have allergies on the second day and you still have a sniffle, as long as the sniffle is not any worse than it was the day before, under these guidelines, you wouldn't have to get a second test or a second doctor's note. It's new or worsening symptoms, not every single time that you have a symptom under the guidelines. And the last thing I'll point out is that the guidelines used to say that if you had a temperature greater than 100 degrees Fahrenheit, and now it says equal to or greater than. So most of us have to change. A lot of school districts have to change their signs and their questionnaires because they all presumably said over 100 degrees, because that's what was stated previously by the Department of Health, just like they used to say 102 because that was the CDC guidelines, and then they all had to revise all of their signs and posters and questionnaires to bring it back down to 100. But those are generally the areas of change, and I would recommend anyone with children or employees that with children, pull those up and print them out and keep them available so that you know exactly when you might be expecting employees not to be able to report to work, or when you might not be able to report to work because your children aren't going to be able to. Oops, see, there we go. That would stop. So I think that it's a good tool. It is a good tool and clear for most people, and certainly happy to answer any questions that anybody has after the rest of the presentation.
So I made a little joke about, trying to keep people on time, but I had no idea that anyone was actually going to take me seriously. So thank you. Thank you, Bethany. I appreciate that. Let's move on to Katie Anderson. Katie's in Albany and has our weekly update from Albany.
All right, it's that time of the week again. Here we go. We have a very busy week. My prediction up front for this week and for the next month is the pace of things in New York. It's going to pick up again. We're going to see lots of stuff coming out of the governor's office again. We're going to see lots. It's just a lot of the factors are the same as they were in March, which is very alarming. But it is, I think that the way that it's going to be dealt with may be very different. So let's get started with the easiest thing. We have this first executive order. This was issued, it supposedly was issued on Sunday, but didn't come out until early Monday morning. This order extends over 30 other executive orders. This extends the orders about virtual meetings for public and municipalities, school boards, all of that jazz. It also extends the notarization. So if you need to have something notarized over Zoom, you can still do that. Significantly, this order says explicitly which components will not be extended in subsequent executive orders. So it explicitly says that the tolling of the statute of limitations for civil cases will end on November 3rd. Motor vehicle registrations, you must have those up to date by November 3rd. The reason I mention both of those things, I understand motor vehicle registrations, that's more of a personal thing rather than a business or employer perspective. But I mention it because there are hundreds of laws that are suspended right now by executive order or modified. And the fact that the governor's office is providing 30 days notice that some of these provisions are going to expire is helpful. It provides some clarity because it shows that the important orders, the important things that continue to be promulgated and pushed along, there will be some form of a notice, likely, when they will end. So the one that always comes to my mind, because it's very easy for me to remember, is the delivery and shipment of alcoholic beverages. That continues to be, that is done by an executive order. It continues to be extended. So keep your eyes out for that. I know many of you have things that are dependent on executive order. This chart, I included it last week. I'm including it again this week. These are yesterday's numbers. The reason I include it is we're looking at hotspots. We're looking at the Mid-Hudson region. We're looking at Rockland County and Orange County. Broome County in the southern tier has a significant hotspot. And New York City, also Nassau. The reason I mention this is when we look at what's happening in New York City, this could be playing out in a couple of weeks across the state. So right now, approximately as of today, there's about 100 public schools and 200 private schools that will be closing to in-person learning. They're within 9 zip codes in New York City. So this is, again, some drama between the mayor of New York City, Bill de Blasio, and Governor Andrew Cuomo. I won't go into detail about that. You can all do that on your own time. But it continues to play out in a dramatic way. And non-essential businesses may end up closing in those zip codes in New York City. The governor yesterday explicitly said that he does not want to close non-essential businesses necessarily by zip code. The reason for that is that zip codes can be seen as overly broad. So on the next slide, you're going to see this is from the governor's PowerPoint yesterday. And I think this is really important to take a look at because this could show what's going to happen in New York going forward. And this also shows the difference between where we were in March and where we are right now. Again, the local zip codes, they're too big, especially in a place like New York City, about the clusters. It could be one block has a cluster and then the rest of the zip code is fine. The reason that that's important is if the governor's office says we're going to start shutting down non-essential businesses where there are clusters, they are probably they're not going to likely do it from zip code. They're currently looking at census data tracts as the smallest denomination of ways to shut down non-essential businesses. The reason I mention this is because our testing is at a place that is astronomically better than it was in March. March 1 was the first date that we had a confirmed COVID case in New York. But really, the coronavirus has been in New York for a longer period of time than that. It has been around for a longer period of time. And right now, our testing data can show you exactly where the clusters are developing. And you can act based on that. The optimistic view here is that because we can get such granular data about where people are testing positive, we will not necessarily have a whole hog shutdown of everything again. We can target where the clusters are, look to those areas, and basically the governor said attack it there. That's important. again, next week, this could all be changed. Next week, there will likely be more information about this, but this demonstrates that we're entering a new phase, for lack of a better term, with COVID and with fighting COVID, and that we're going to be going forward with, what's next. Finally, the travel advisory states, this is from last week. It still hasn't been released yet today. It seems that the governor is now taken to releasing this in the afternoon. But this is, I expect that there's going to be quite a few states added this week. It doesn't look like any are really coming off. And this is going to continue. New York is at 6.6% of the metrics on this, where you're supposed to be below, 10%. So New York itself is getting pretty close to being added to the list, which it won't be. But we are in a more dangerous place than we were in July. And that's because we're all indoors again. And with that, there's one other thing to mention. SUNY Cortland has now gone to all remote learning for the next 2 weeks at least, as of yesterday. That will continue to be a developing situation. Obviously, college campuses are extremely different from your, K through 12s, and what happens there is very different. And with that, Pete, it's all back to you.
Okay, Katie, thank you. Interesting observations on, I think, a more targeted approach here, and also a little troubling, the numbers that we're seeing. So, okay, let's move on to Steve Ricca. Steve's in our Buffalo office, and is going to talk a little bit about OSHA recording and reporting requirements. We've touched on this, but it's a topic that people keep asking about and bears reviewing. Steve, take it away.
Thanks, Peter, and hello, everybody. Unfortunately, things are getting a little bit hotter in terms of the data, and given that the availability of testing has been vastly improved, I think we can reasonably expect to see a higher incidence of reported COVID cases for a number of reasons. So today, we've had a lot of focus on the New York State reopening requirements. I just want to circle back and remind everyone that OSHA is standing in the wings and has a particular interest for, obviously, and reported COVID fatalities and hospitalizations. So I just want to spend a few minutes just reinforcing some important distinctions that employers should keep in mind when it comes to COVID cases. I'm going to talk about the basic criteria for a reportable illness and injury under the logs, the 300 log requirements, and then maybe zero in a little bit on how one determines if a COVID case or illness is work-related, which is largely driven by recent OSHA guidance. And finally, I want to talk about the very different considerations in considering whether a fatality versus a hospitalization is reported. This is extremely significant because obviously reporting to OSHA one of these two things can and likely will trigger an inspection. So the employer should be aware of some issues to keep in mind when sorting all of this out. So what's a recordable illness? What do you need to put on your 300 log? 3 conditions must be met. And this is for employers with greater than 10 employees generally. You need to have a confirmed case of COVID. That's driven by CDC guidance, presumptive positive cases, laboratory confirmed cases. I'm not going to drill down on that. The second criteria is whether the illness is work-related, and I will drill down on that a little bit. Third criteria is that the case involves one or more of the general recording criteria: death, days away from work, restricted work, job transfers. The list goes on. These are set forth in 1904.7. But what I really want to do is spend time on, the issue of whether a COVID illness is work-related, and then finally, whether you have to actually not just record it, but report it to OSHA. You may have noticed that until mid-May, OSHA had issued guidance that relaxed standards for everyone other than healthcare providers and frontline workers. That guidance was since replaced by an OSHA revised enforcement guidance on May 19th. That became effective May 26th. That basically calls for you as the employer, when a COVID case among one of your workers is brought to your attention, to consider a number of things. You have to make a reasonable investigation, and the guidance talks a little bit about what a reasonable investigation is. It expects you as an employer to consider information that's reasonably available to you, and then helpfully it goes on to provide examples of what is and is not likely work-related. In both instances, the examples would provide a guidepost if there's no, quote unquote, alternative explanation. So let's talk about that a little bit. What would constitute a reasonable investigation? You've got to talk to the employee. Ask how he believes he contracted the illness and take that information into consideration. Discuss what the employee's doing outside of work, being careful to respect your employee's privacy. Third, consider that employee's work environment. Where does he work in your operations? Who does he work with? Does he work closely with others? Have there been any other cases? Kind of common sense stuff. The evidence that an employer needs to consider, the reasonably available evidence, can be such things as notes and communications from medical providers. Again, this is a situation where a standard of reasonableness is called for. You don't have to conduct a sophisticated medical evaluation, nor are you expected to know how to do that. So what would be an example of a likely work-related COVID case? This would be a situation where you have several cases among those who work closely together. This could be a situation where an employee contracted the illness after lengthy, close exposure to a particular person that tested positive for COVID. Consider the functions that this employee performs. Do the job duties require frequent, close exposure to the general public, particularly in an area with ongoing community transmission? In New York State, that would apply to much of the state. What are the examples of what wouldn't be likely work-related? One example would be a situation where you have an isolated employee, one who has no frequent contact with the general public. Again, it's a common sense evaluation. It is something that will, in many cases, present unclear questions. Another example of what would not be work-related would be a situation where your employee is very active outside of the workplace, going to large gatherings, being in contact with people who have tested positive, etc. So bottom line, when you're considering whether to report on a OSHA injury and illness log, and you are considering whether that illness is work-related, conduct a reasonable inquiry, consider all the information available to you, including information obtained from the employee about activities both inside and outside of the workplace. And if it's a close call, depending on your tolerance for risk, I would suggest that you record the positive case. And this is an obligation that would extend above and beyond any requirements under the New York State reopening guidelines, which I believe are more relaxed. The requirement to let the local health department know. So let's talk now finally about reporting fatalities and hospitalizations. There's some very interesting legal issues here, or factual and legal criteria that employers should take into account very, very carefully before you pick up the phone and dial the OSHA hotline. Certain situations require reporting to your OSHA area office or the national telephone line. Fatalities have to be reported within 8 hours of a COVID-related fatality. And I know what you're thinking. This is pretty complicated. How are we supposed to know? There's latency periods. It's ranging from 2 days to 2 weeks. This is some complicated stuff. And you're right. The fatality has to occur within 30 days of an exposure in the workplace. So already we're starting to get into a situation where you've got to connect a lot of breadcrumbs here. So stated in a different way, if an employer learns that an employee died within 30 days of a work-related incident and determines after the fact that the cause of death was in fact work-related, employing a lot of the considerations I discussed earlier, you have to report that fatality within 8 hours of that determination. So bottom line, fatalities, 8 hours. 8 hours from the fatality, or 8 hours from your determination that the fatality occurred within 30 days of a workplace incident and that the illness was work-related. A lot going on there. Of course, if a fatality is involved as a practical matter, to really not want to notify OSHA, I would submit that it may be difficult to avoid doing so, particularly given overlapping requirements under state reopening guidelines. But I just wanted to point out that these particular criteria exist. It's a little bit more complicated with hospitalizations. In fact, I've been reading a lot of press releases about reporting of hospitalizations, and a lot of the detail gets lost in the reporting. We are talking about an obligation to report inpatient hospitalizations, a very significant distinction. If an employer becomes aware of a work-related exposure incident, he has, involving a COVID test, he has to report within 24 hours of learning of that. But two elements have to be present for a visit to the hospital to be reported. I already mentioned there has to be an inpatient hospitalization. This is defined as a formal admission to the inpatient service of a medical facility. Now, I've had situations with clients where this issue has come up, not COVID related, but injury related. And it presents a practical problem. How do you know if the employee has been formally admitted to the hospital? Oftentimes a loved one will call, the word will get out, coworkers will check in. But I suppose as a practical limitation here, the hospital may not be willing to tell somebody over the phone, particularly not the employer, the status of an intake. So I would suggest that all employers who learn of an employee who went to the hospital supposedly in connection with a COVID exposure, to be very careful about getting as much information as you can about the status. Treatment in an emergency room only is not reportable based on OSHA guidance. An overnight stay in the hospital is not by definition inpatient hospitalization. So, you really want to scrutinize the 1904.39 criteria and make sure that you consider all of these things. Another main element of reportability for hospitalizations is that there was delivery of medical care or treatment after formal admission. You don't have to report an inpatient hospitalization that only involves observation or diagnostic testing. Now, this is language from pre-COVID regulations, and it obviously presents a conundrum when, frankly, that's probably precisely the reason the employee goes to the hospital in the first place. But be that as it may, if an employee, for example, thinks he's got COVID and goes to the hospital for a diagnosis, that's not necessarily reportable. So the moral here is familiarize yourself with the reporting obligations, comply with the recording obligations if in doubt, but be very careful about making reports to OSHA of fatalities or hospitalizations until you've considered all the regulatory criteria. So with that, Peter, I present it back to you.
Thanks, Steve. I appreciate it. We're going to turn now to Rick Weber, and Rick's going to talk a little bit about some recent litigation developments. Before we do that, I do want to offer a little teaser, however. We're going to have a little bonus segment today, and Andrew Bobrecht's going to talk about what you do if someone is exposed or test positive. So if folks can hang in with us, we'll probably run a little bit over, but I think it's hopefully be well worth your time. Go ahead, Rick, take it away.
Thanks, Pete. I'll try and be quick so Andy has enough time. Hopefully you can all hear me. I had some local IT issues, but I hopefully have those resolved. What I want to talk to you about generally is, as you may know, there have been a series of challenges to Governor Cuomo's various restrictions, both issued by Cuomo directly and various agencies, on the types of activities and enterprises that can be undertaken during the COVID pandemic. As of the end of September, there were at least 53 different lawsuits on file that in one way or another were challenging some of these COVID-related restrictions. And I thought it would make sense to just take a look at some of the themes that have been developing over time on these. It appears that a lot of the common themes are that the directives or the prohibitions are arbitrary in some fashion or are just unsupported by the evidence. That really this is a implementation of some kind of restriction that's not required or frankly useful in helping to stem the COVID-19 pandemic. Also, a common theme is that certain businesses are being treated differently, even though the plaintiffs would assert that their business is similarly situated, either geographically or in the type or nature of business, than some other enterprises that are allowed to operate. Also, there's some theory that the agency that may have been issuing the restriction has exceeded its authority, and various constitutional arguments as well concerning due process or equal protection of the law. One of the things that also frequently gets mentioned is that if there was a rationale for having a restriction, it was part of what we were all talking about in March and April, which was flatten the curve, right? Help flatten the curve so emergency workers can address the sick and really protect us from having a full-scale crisis in healthcare. And that our numbers currently are actually pretty good. And the progress that we've made would warrant lifting certain restrictions that may have had some rational basis to exist back in March or April. So next slide, please. I thought it'd be good to just highlight two recent cases that give an indication of some of the arguments that are happening. Sportsman's Tavern, you might have heard about in Buffalo. This decision was a decision on a motion practice on an action that was commenced by a tavern owner. And this tavern owner wanted to have music at his bar. As you may understand or may be aware, the governor had restricted that in an effort to cut down on the number of attendees who would attend various nightclubs or taverns. A complaint was filed. The judge in Buffalo, the Erie County Supreme Court, issued a decision last week indicating that the prohibition was unconstitutional. It's not necessarily as clear as one would hope. That determination likely only applies to that plaintiff on that particular motion. And it's very clear that that plaintiff is still going to be required to follow any state guidelines and local guidelines regarding safety protocols for operating the tavern. But the point of that lawsuit was to try and allow for music to be played at the tavern, and at least in Erie County and with this particular tavern, that is going to be allowed. Interestingly, it is consistent with at least part of a separate decision that was issued by the Southern District of New York, a federal court, on an action that was brought by NIVA. This was a group of independent venues downstate seeking the same type of relief. And that court noted that at least in part, music should be allowed, or that it doesn't make any sense to ban incidental music, music that is not subject to a cover charge, right? Where the draw is not the band. The draw is the restaurant or the tavern itself, and the music is incidental to the draw. But as to advertised or ticketed shows and cover charges, the Southern District did not go so far as to set that restriction aside. Next slide, please. A new lawsuit, it's only just been filed. It's not entirely clear where it's going to go, but it shares similar themes. The Humphrey lawsuit was filed by the mother of an aspiring high school senior quarterback in Niagara County, and it was styled as a class action lawsuit, and the goal of the lawsuit is to enjoin enforcement of shutdown orders as they would apply to high school football. It's going to be interesting to see how this case unfolds over time, but the arguments really echo almost all of the types of arguments that I had indicated earlier were being raised in these types of cases. Number one, that we were all working to flatten the curve, but now the curve has been flattened. Number two, that other football enterprises, notably they cite Syracuse University and SUNY Buffalo, are going to be able to play football. They know that other similar sports, such as high school soccer, which also involves physical contact, is able to proceed. And they know that in 36 other states, high school football is proceeding. The legal theories, again, echo the legal theories that we're seeing in these cases, right? That there's been some type of violation of procedural due process, violation of equal protection rights, a claim of tortious interference with economic advantage, which I thought was interesting. The argument is that by denying a football season to these aspiring athletes, you are denying them the possibility to showcase their talents for colleges that may wish to offer academic scholarships, or more importantly in this case, athletic scholarships, which may facilitate families sending their kids to school when they may not otherwise be able to do so. So a lot of interesting arguments. We'll have to wait and see how that unfolds. Real quickly, I did want to brief two other points that have popped up. They're not directly related to these cases. The first development from the courts is that the court system has learned that it will be dealing with a $300 million budget shortfall. And so the New York State court system is trying to get its hands around that. One of the initial methods of getting hands around it appears to be to allow senior judges who can petition the court for an extension of their status in certain 2-year increments to forego that. In other words, they will prohibit those senior judges from taking that additional time. But frankly, that hasn't been decided yet, and that's just one of the possible measures that's floated. And clearly, it's of great concern to the court system that they're going to have to fill this budget gap. Finally, since the pandemic first struck in March, all courts in New York have been living with a series of directives from Governor Cuomo. One of the more interesting ones was a directive that either told or stayed statute of limitations and other certain filing deadlines in court actions. There's some disagreement among the bar as to whether it was a toll or whether it was a stay, but it appears now that deadline is that prohibition on these deadlines has been extended into early November, with the caveat that that's going to be the last extension. So what we anticipate is that there's going to be a whole lot of activity in the New York State court systems in early November. Pete, that's all I have.
Thank you, Rick. Appreciate it. A lot of content there. Let's go to Andy. Andy Bobreck, as I mentioned, is going to talk a little bit about the exposure issues, testing positive. Andy, take it away.
Great. Thanks a lot, Pete. Good afternoon, everyone. Beautiful day here in Syracuse. Beautiful fall day. I guess this is my public service announcement to, if you can, take a drive, take a walk, take a hike, enjoy the colors in the Northeast here, and certainly here in Central New York. What I just had talked to Pete before today's program a little bit. I'm seeing, and I think others here are seeing, more and more questions from clients where we're getting employees who are testing positive, employees who are reporting symptoms of COVID, employees who are reporting close contact of others who have been diagnosed with COVID. And it's leading to a question that we were dealing with months ago and probably off the top of our head could address. But since then, and since matters had improved, we kind of need to dust off our guidance and thoughts and expertise on those. So I want to just cover a few of those issues quickly. I'll push out.
Andy, you're muted. I don't know what happened there. You got muted inadvertently.
Oh, okay. How's that, Pete?
That's good.
Okay. I beg your pardon. Where did I leave off?
You said you were going to push something out or something
Okay.
yeah.
Great. Yeah, I just pushed out a chat to everybody. It's a link to the state's guidance on return to work, specifically the State Department of Health. And that is the guidance that when you look at the detailed plans that the state has put out for certain industries during the phases, that's what they link to in many of those plans. So it's a good reference. Obviously, you're going to also want to take a look at your own workplace safety and infection control plans, which should address this issue and have those ready when it comes time to deal with this issue. But again, one of the questions that we get frequently is, hey, an employee has reported that they have a sore throat or headache at work. What do we do in that situation? Here, you're going to want to take a look at your own plan, but very clearly that employee needs to be separated immediately and sent home at that time safely. They should also be given advice to seek care from a healthcare provider in this situation. And then the question that comes up commonly after this is, well, okay, when can they return to work? There, the state guidance is clear that they can only return to work after completing at least 10 days of isolation from the onset of those symptoms or upon receipt of a negative COVID test result. So again, in those two situations, and obviously this can branch off in different directions depending on what happens following the symptoms, but absent anything else, that's the directive there. And just to note that the symptoms, they've been relatively static of late, but they do change. They have changed over time. The CDC is really the source of authority on these symptoms. The guidance from New York often links or directs interested parties to the CDC guidance. So just be sure to check that. A quick Google of CDC COVID-19 symptoms will take you right to the correct webpage. Here too, just what you see on the page are two links. One is a link, just a tiny URL to that same guidance from the Department of Health that I mentioned. The second is some more generic guidance that the CDC has put out relative to return to work and work-related issues in COVID. Again, more generic, more general, but some insight there and things you want to keep in mind, certainly. So what if an employee tests positive for COVID? Again, this has happened. You may get a call that, hey, I tested positive. It may be a situation where somebody was experiencing symptoms, went out, got tested, and they tested positive. In that situation, they're only able to return to work after at least 10 days of isolation from the onset of symptoms, or 10 days of isolation after the first positive test result if they remain asymptomatic. And again, I realize I'm going through this fairly quickly. This is all spelled out very clearly in the DOH guidance. Just a PS there, keep in mind, in all likelihood, that individual is going to be subject to a governmental quarantine order if they test positive. You're probably going to be in touch with the State Department of Health at the State Department of Health initiative, but we're going to want to communicate with them as well. With respect to that quarantine order, remember our potential obligations under the FFCRA, as well as under the state legislation to provide paid leave to eligible employees in those circumstances. How about an employee who reports that their spouse just tested positive for COVID-19? What do we do in that situation? It'll depend on a number of factors, and there's a couple different paths that you'll go down in this situation. But let's say you have somebody, and again, it's going to be somebody who is engaged in close and proximate contact. Certainly in the case of a spouse, that's likely to be the case where they live together. But the state has specifically indicated that close and proximate contact is where you have contact with someone within 6 feet of that infected person for at least 10 minutes. Starting 48 hours before their illness, until from the illness onset until the time that person was isolated. So again, that's the definition of close contact. If the employee has had close contact with that individual for a prolonged period and they have COVID-19 related symptoms, then they can only return to work after completing a 10-day isolation period that starts from the beginning of the onset of symptoms. If the employee has close or proximate contact with an infected person and they are not experiencing any COVID symptoms, then that isolation period, self-quarantine period, is 14 days, according to the DOH guidance. With one exception there, Pete, if this employee is deemed to be essential and critical for the operation or safety of the workplace, there's an opportunity to treat that employee a bit differently and potentially have them return to work, again, if they're not experiencing any symptoms. If you find yourself in this situation, I would encourage you to contact your bond attorney. There are some steps that you need to walk through and some documentation that you're going to want to have in place if you need to return that employee. All right, Pete, what if an employee refuses medical care or COVID-19 test? I've heard this one several times. There's no silver bullet answer here. I think you're gonna need to evaluate the situation, engage the employee, try to have an understanding of why the employee is not willing to take that test. Are there any medical or health issues at play? You might get the, well, I don't believe in COVID answer for why they're not going to get tested. Of course, that's not that subjective belief on the part of the employee is not a legitimate basis for them to refuse to comply with our policy requirements dealing with COVID. But I think you're going to have to evaluate it and take appropriate action. And at the end of the day, that may be preventing the employee from accessing the workplace. But again, we're going to want to put our ADA, our human rights law hats on, as well as keep in mind our obligations under the various COVID-related leave laws, and just proceed cautiously and carefully. But certainly our hands aren't going to be tied in that situation. All right, so I'm getting several texts, let's say, from workers about another employee who keeps refusing to wear a mask in common areas. Again, in this one, I get the explanation of, well, yeah, I think COVID's a hoax. It's a hoax. I don't need to wear a mask. And again, I think the counseling point there when that happens is to explain to the employee certainly that, again, their own subjective viewpoint and belief doesn't matter here in the workplace. We have certain requirements and policies that are in place. We are empowered to put forth those policies and to require our employees to comply with them, irrespective of their own personal viewpoints. But here, I think you do need to take maybe a half step back. Can you document whether or not this is happening? Do you have some videotape to see what's happening? And then I think you do need to engage the employee. And when I say take a half step back, certainly if there's some medical issue or other issue relating to protected status in the employee wearing the mask, I think that's something you want to have a discussion about at the very least and understand the employee's perspective there. But with that information and assuming there's no such issues there, certainly we can hold and require our employees to take the appropriate precautions that are coming down from the state and that we're implementing. And if they fail to do that, to issue appropriate discipline. There, I just want to make sure that, of course, the punishment fits the crime, as they say, and that we've got our ducks in a row in terms of documentation and process. So, Pete, quickly, I apologize for the brevity of this. We could probably spend a lot more time, but some quick thoughts and some issues that we're facing there.
No, thanks, Andy. I mean, I think the one overriding thing that we've all experienced throughout this is that the rules, they have changed and they have evolved as our understanding has changed and evolved, and frankly, as the situation has changed and evolved. So I see in the Q&A some questions about, when did this change or that change? And I think, these things happen without a lot of fanfare. So my rough, sort of best advice would be, when you have these situations, let's remember what we know, what we've learned to this point, but probably good to check the most recent guidance, perhaps, consult with your attorneys, make sure that, you haven't missed anything, so that you're up to date as to what the current best practices are and frankly, what the current requirements are. Okay, well, thanks everybody for being with us. We ran a little bit over, but we wanted to get you all that content today. We'll be back at it again next week. Thanks for being with us, and everybody stay safe.